Appeals Division 1 is now in session.
Thank you. Please be seated. All right, we're here this morning for oral argument in our case number CV23-0606, Sync Title versus the Arizona Corporation Commission. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you want. Please keep in mind that we've read the briefs and conferenced the case this morning. And with that, counsel, you may proceed.
Good morning, Judge Catlett and Judge Howe and Judge Perkins. Thank you for this opportunity here. And even though you mentioned at the beginning, Judge Catlett, I will attempt to watch the clock carefully and hopefully reserve some time for rebuttal. And also in the interest of time, I should also bring something else up. But first, to comply with the court's dictate there, I'd like to announce myself as Phil Escalar. I represent Sync Title Agency, and we are, of course, the appellants in this action. There were other appellants. They have been dismissed, and Sync stands alone, although one could argue, as I'll mention later, that we essentially are arguing on behalf of them as well, since clearing Sync essentially requires arguing that the appellants did not, the other appellants, the dismissed appellants, did not violate the statutes that they were alleged to violate. With
Counsel,
respect, oh yes.
Before we get into, on that point, I guess I wanted to just maybe clarify something with you. So Sync Title formed in May of 2018, or at least that's sort of the documentation of the LLC. The sales, the purchase agreement here was between the Williams and the individuals Joplin and Olson. Sync was not a party to that purchase agreement. Is that correct?
If I could ask, Your Honor, if you that last part of the question. So we have Sync being established in 2018. The Williams would be signing a contract with Sync much, much later.
Correct.
But
the contract was not with Sync.
That's correct.
It was with Joplin and Olson directly.
That is correct.
So would it be fair then to say that and this is consistent with what the commission found, the sale that occurred here of the just under 20% was directly from Joplin and Olson to the Williams?
That is correct. In fact, I think we've argued that as well. Now, Sync was interposed. I'm sorry, go ahead.
So the importance of that, just for purposes of this right now, is Joplin and Olson are not a party to this appeal, but the transaction that is the subject of the appeal was only between Joplin and Olson and the Williams.
I suppose, and they're not here to argue otherwise, but my interpretation would be they were part of the appeal. They filed a joint opening brief.
Right, but they've been dismissed.
They have been dismissed.
In terms of what we can do, we have a transaction which is a sale of an interest that Joplin and Olson made to the Williams. So that transaction, we don't have the parties to that transaction in front of us anymore.
That's correct. Sync is part and parcel of that transaction, acting as a conduit, accepting money and.
Right, if Sync didn't make the sale here,
that's correct,
because Joplin and Olson did, then how can Sync be held liable for making fraudulent statements in connection with the sale or offer of a security, or with the sale of an unregistered security, if that sale was not between Sync and the Williamses, it was between Joplin and Olson and the Williamses, and Joplin and Olson are no longer parties to this appeal, even if they maybe were technically to begin with?
I see, Your Honor. And my best answer to that would be that Olson and Joplin, at times at least, that the ALJ and I presume the commission found were acting on behalf of Sync They were the actuators of Sync acting rather than themselves.
Well, counsel, they may very well have had an intent to benefit Sync in what they were doing, but they were selling their own property for their own purposes. They may want to send money into Sync, but that's between them and Sync. That's not between Sync and the Williamses.
I see it, Your Honor, and I would even agree that at the moment of sale itself, it is between Olson and Joplin and the Williamses. However, this sale is more of a
And
process.
we could vacate the ACC decision as to Sync on that ground alone, correct?
I wonder
Sync is
if...
not the seller,
Correct, Your Honor.
and so Sync can't make fraudulent statements in connection with the sale of a security, and Sync didn't sell an unregistered security. If anyone did, it was Joplin and Olson.
As far as you are phrasing it there, Your Honor, I would agree. Again, I think the facts show that Sync is just hopelessly intertwined in it, though, in the sense that, for instance, providing disclosures to the extent some were. I think it's quite arguable that Sync was doing it. It was, again, it's just Olson and Joplin. There's no pretending otherwise. It's just those two in the corporation. But they are acting on behalf of Sync. Sync is doing the disclosing, and perhaps then, because, again, it's in connection with the sale, not necessarily just the moment of sale, the statute. Sync is drawn into it because they are acting in connection with the sale of securities.
I'm a little confused by your position. You represent Sync.
That's correct, Your Honor.
We've posited that perhaps Sync shouldn't have been found liable for any of this. Aren't you happy with that?
A welcome. That would be a welcome for Sync, obviously. That would be a welcome decision. However, Sync is nonetheless offended that it's been accused of, because I think the ACC decision only attributes a certain amount to Sync for securities fraud, while also, because if the fine is $5,000, and $3,000, I believe, is for securities fraud, while the remaining amounts presumably are for violation of in connection with the sale of securities. So while it could technically be vacated, I believe it should be argued that, or that Sync would like to argue that these violations didn't happen to begin with, regardless of who did it. And that obviously, it seems like the cleanest way to remove all doubt that whether or not Sync actually committed any of these violations is to prove that they didn't happen to begin with. Not that just Sync didn't do it, but that nobody did. Because sometimes I suppose it's not clear in the record who's acting on behalf of who. Is Sync acting at that moment, or is it Olson and Joplin? So that's at least how I've conceptually approached it, but I definitely take your, what you said there, Judge Howe. I mean, obviously Sync, as a non-natural person, would be thrilled to be dismissed from the case if it was vacated as to Sync. But that, at least that's a justification on why we're here.
I mean, regardless of what we say, Joplin and Olson are on the hook because they have an ACC order or decision that holds them liable, and that was affirmed by the Superior Court, and they've not appealed it.
Correct. And again, retreating.
So
to
even
the
even if we were to say that get over this threshold issue about who was the seller and who were the buyers, and say, okay, it was a private offering, not a public offering, and there were no fraudulent statements made, that still only helps Sync. It doesn't help Joplin and Olson.
Well, I believe we briefed, it's just a small part of our brief.
Because we're still only going to vacate as to Sync.
Correct.
Even if we were to get to those those more substantive issues.
Sure. I see, Your Honor, and I wonder if Sync actually agrees. I think we've cited a case where we feel like sometimes if party and issue intertwinement is so hopelessly intertwined that the judgment must be required as to one issue or judgment must be required as to one party, that it doesn't make sense and it has to be vacated as to all. At least that's the conceptual approach that I've read into that case. We didn't brief that at length. I think it was just an aside in a single paragraph, but I believe we asked the court to vacate it all for those reasons based on the cases that were cited there. That said, appreciate the question, Judge Perkins, and I hope I was able to answer that. And if I could, while I'm happy to speak about 1844A1 and 44-1991, securities fraud, and the unregistered sale of securities, it seems like we might be positioned here for a potentially unique constitutional moment, and I'd like to move, if I could, beyond the facts, which are really well briefed given the 3 levels we've been at, and move on to discussing this relatively new thing that the Court of Appeals asked us to at least be prepared to argue. So with the remaining minutes I've had, absent any other questions the court may have with respect to the facts, I'd like to move on to that. And the first question was, when does the statutory claim or offense require a jury trial? And of course, that comes out of Article 23 of the Arizona Constitution, and it's been repeatedly held, and it makes sense, that the Arizona Constitution did not create a jury trial right. It only preserved a right that had already existed at the time of statehood in 1912. That said, as you fast forward through the years, statutes began to be enacted, and it started to become perhaps a little unclear whether a statute was based on or simply a recodification of common law, a modification of common law, or something else entirely, just a new statute that had nothing to do with common law. And cases, of course, began to come up through the court system, and a rule began to be established. We have the basic constitutional principle that the jury trial is inviolate, but then we have the basic principle as well that only holds true for common law actions that existed at the time of statehood. So the courts developed a rule stating that if the newer statutory claim or offense has a common law antecedent, then the jury trial would continue to be held inviolate.
And you agree that test is different than the test the U.S. Supreme Court applies for the 7th Amendment, and that it applied in Jarkissi?
It's awfully similar, Your Honor. It's awfully similar. Obviously, that's 7th Amendment. We have Article 23. We concede that different jurisprudences, so to speak, have grown up around each of those, Article 23 versus the 7th Amendment. That said, the underlying principles, I don't think anyone would dispute, are at least very similar, that the U.S. Supreme Court also looks back to whether something is fundamentally legal in nature and therefore a common law claim.
But the Supreme Court in Jarkissi really focused on the remedy, and we do have our case law here telling us that we do more of a sort of an explicit comparison of elements of the common law antecedent and the statutory claim. So those look different, right? That analysis? They
do. And the way I would attempt to characterize it, Your Honor, is with respect to, and I'll go ahead and say it's the Darendahl case is one of the cases I think both sides would agree that's fairly instructive with respect to focusing on the claim and the elements of the claim and whether or not it has an antecedent in common law. Versus the deep focus on the remedy that the Supreme Court had. However, we of course have this overriding, let me take that back, we have this instructive, persuasive principle to look to the federal court system, not necessarily to perfectly harmonize the Arizona securities regulatory regime with the federal regime, but at least look to it because it is instructive on how to interpret Arizona's own Security Act. A great example would be 1991 section.
I don't think the legislature there was telling us to look to federal case law in interpreting the jury trial right in the Arizona Constitution.
That's correct. That would be an extension, and I admit that. But nonetheless, the principle of relative harmonization in this case would at least, I believe, make it somewhat instructive to look at that principle of looking at the remedy.
Here's another hang-up I have, and I think the state of Arizona points it out in its amicus brief. So the SEC is a creature of Congress. It was created through legislative act. The ACC is created by the Arizona Constitution. And the Arizona Constitution, I think, says both that the ACC has authority over securities corporations in Arizona that have issued securities, and then it has the constitutional authority to impose fines. So to me, that's a textual clue that the Arizona founders did not think that you would get a jury trial when the ACC brings proceedings in-house and imposes fines. I don't see how the founders could have given that power while at the same time saying you have a jury trial right, because I don't think they were thinking the ACC would be holding jury trials.
Correct.
So what do I do with that, what I view as kind of a inconsistency?
That is quite the inconsistency. And I think for the purposes of this time, Your Honor, we probably would best then focus on why we win, which is the Darendahl elements, rather than, I believe that was quite interesting, Your Honor, with respect to giving them authority to impose fines and that sort of thing. But nonetheless, we have our case law that says you're still entitled to a jury trial, nonetheless, if it dates back to common law. I don't know that we have an absolute pronouncement that the ACC, for instance, is exempt from that. That said, when we look at the Darendahl elements, or excuse the pronunciation, I would say, in Darendahl, we're looking for elements of a common law claim that is substantially similar, not identical, just substantially similar. And when it comes to 1991, how similar are they from the elements of common law fraud, that is, versus statutory fraud? Well, our case law, I think, gives us a lot of clues there. It's obviously not identical. And when we look at prior cases that have taken a look at this and grappled with this issue, they've clearly come to the conclusion that what really matters is the character and grade, and I'll even call it the nature of the statute in question, and whether the same basic conduct is prohibited. A great example of that was, I think, the Ers and Bowding cases that were cited in Darendahl, where in one case, I think it was the Ers case, the statute actually had fewer elements, yet they nonetheless, that is, the statute had fewer elements than the common law cause of action. The common law cause of...
What is the overlap between the securities fraud claims that the ACC brought in this case and a federal securities fraud claim that the SEC would bring? Aren't they the same elements?
I think they're exactly the same elements.
Didn't the Arizona legislature just lift the federal cause of action and create it, codify it in Arizona law?
I believe so, and I don't think there's any dispute with respect to that. 1991 is essentially, I think, the identical analog of 10b-5.
So to the extent the U.S. Supreme Court analyzed the elements of a federal securities law claim in Jarkissi, that same analysis, even though it's not quote-unquote binding on us, it would apply to what is essentially an identical cause of action under Arizona state law.
I would agree, unless substantial differences could be pointed out. I would certainly agree. Noticing my time here, I better just jump right to it, Your Honor. And we think the nature of common law and the nature of our securities law prohibition, they're essentially the same. They prohibit the same conduct, which is false and misleading statements or omissions. Yes, common law has many more elements, but the same core conduct is what really matters under our case law as well as federal case law. So, and I believe all the cases cited by the opposition are quite distinguishable. For instance, the drag racing is different because drag racing did not contain reckless endangerment inherently. When the legislature prohibited drag racing, and then the party in Darendahl tried to bring it back to common law through reckless endangerment, the court noted, well, there are certain times when drag racing isn't inherently reckless. Therefore, it's not universally linked back. But here, common law fraud and statutory fraud, they are linked. And they're always linked by false and misleading statements or omissions that are material. That's really the core of common law fraud, and that's really the core of statutory fraud. Therefore, because it dates back to common law at the time of statehood, we were entitled to a jury trial. And finally, I'd point out that in the amicus brief of the National Association, there's a lot of ink spilled regarding how important it is to maintain this regime of enforcement. We don't believe that imposing a jury trial requirement on Section 1991 harms their enforcement capabilities at all. It just moves to a different forum. So with respect to their ability to enforce, it's all still there. And they would still remain and have all of their equitable powers that they would need, restitution and so forth. Those I don't believe would be disturbed. But if they're trying to, to put it another way, I see I'm out of time, Your Honor. That said, if there's any final question I could answer, I'd be happy to do so. Otherwise, I see I'm out of time.
Thank you.
Thank you, Your Honor.
May it please the court, Paul Kitchen for the Arizona Corporation Commission. I'd like to start with Judge Perkins' question about SYNC's liability because it's a helpful illustration of how securities fraud and securities claims in general differ from common law fraud. Common law fraud involves a speaker of a representation and a hearer of the representation, the two parties to the transaction. But securities liability is not limited to the parties. The Securities Act defines the sale of a security as any attempt to dispose of a security or for value, including but not limited to making a contract for the sale of a security. So SYNC sold the security in its sense that it was part of the sales pitch that led to the transaction, even if the paperwork doesn't reflect it as being the seller. Also, the Securities Act, the violations at stake here all include offers to sell securities, even if they aren't consummated.
I guess, so my view is that SYNC issued 100% interest to Joplin and Olson in May of 2018. And then 6 or 7 months go by, and Joplin and Olson then sell 20% of that interest to the Williamses. The purchase agreement says that Joplin and Olson are the sellers. The ACC's decision says that sellers are Mr. Olson and Ms. Joplin, and buyers are Mrs. and Mr. Williams. So I guess I don't understand how 7 months later SYNC is the seller at that point. If SYNC was a corporation and it had issued 100 shares to begin with and then wanted additional funding, so it was going to issue 100 additional shares, at that point I could see how SYNC was selling something, and maybe if Joplin and Olson were out pitching those additional 100 shares to other folks, then they could be acting as agents for purposes of that transaction. But I don't see the connection in this case between SYNC and the Williamses. Can you help me?
Sure, Your Honor. One issue is that the text of the agreement is actually a change from what the pitch had been. Olson's pitch to them and Ms. Joplin's pitch to them was, you want to make an investment in SYNC to help SYNC grow. That sounds like they're giving money to SYNC to fuel the business, not simply purchasing shares from those two individuals. And the agreement has an internal inconsistency, which is that the transaction is with the individuals, but the payment is payable to SYNC. And that leads to another reason why SYNC is liable.
But then your claim is that they committed fraud because they ended up using those funds for their own individual purposes when they were telling the Williamses that they were going to use it to fund the operations.
Yes, Your Honor.
So I can see how that gets you to fraud with respect to Joplin and Olson, but I still don't see how those statements in and of themselves make this a sale between SYNC and the Williamses.
Let me offer another explanation that might be simpler, which is that ARS 44-2003 extends all securities sales liability to anyone who makes, participates in, or induces an unlawful sale. And a case law on what participation means includes anyone who participates financially in the transaction. So SYNC is a participant in the sale because it obtained 100% of the sales proceeds. And in fact, the commission made a finding to that effect. And on page 71 of the decision, it finds that it is clear that respondents all participated in the transaction at issue. So if no other reason, the participation liability suffices to cover Sync's liability for all the violations here.
Would it have been different if the funds had been deposited directly into Joplin and Olson's account and then they subsequently put it into Sync's account? Would that have made a difference?
Not necessarily. Well, no, Your Honor, because if Sync knew that it is going to be the recipient of the funds.
But Sync doesn't know anything. Sync's another entity.
Well, Sync knows what Joplin and Olson know, which is that when they're pitching an investment in Sync, that's also Sync acting. You don't need to make that finding because the participation liability satisfies it. But for the sake of a complete argument here, because the Commission is going to take this position in other cases, offer and sale liability and participation liability are intentionally quite broad to capture all the participants in the transaction so that people can't just use the wording of the document, of the instrument, to wall themselves off from liability when really they should be held liable. The legislature anticipated that, so it has made liability intentionally quite broad. And I forget the case name, but one of the cases interpreting this make, participate, and induce liability says that this is sweeping language of inclusion.
Right, but the portion of the ACC decision talking about who offered and sold the securities, I think it's on page 53 of the decision, it says Ms. Joplin and Mr. Olson offered and sold the Williams as an investment contract for the 19.9% membership interest in Sync. And then the last sentence is, by virtue of the actions of its managing members, who are its agents, Sync also engaged in selling the security. And then cites three provisions of 44-1801, which is the section dealing with definitions. So I guess I don't see there any discussion about the broad sweeping nature of in connection with in that finding. And with respect to agency, I don't see how Joplin and Williams are acting as agents of Sync at that point, 7 months later, when they're just selling their own personal stake in the business. I mean, if I say I participate in an IPO and I buy 500 shares and I decide 7 months later that I want to turn around and sell those shares to someone else, I'm not acting as an agent of the business that did the IPO. I'm selling those out of my own personal property.
I understand, Your Honor, but the Commission was not required to accept that the language, that the way it was structured in the instrument was the truth of the underlying offer and sale. Olson and Joplin pitched this opportunity as being an investment of Sync, not merely a purchase of their shares. And the Commission was entitled to rely on that evidence to find implicitly or explicitly that
Did the Commission find explicitly anywhere that this liability for Sync is on the basis of participation or inducement?
It did, Your Honor. Page 71 is where the quoted, it is clear that respondents all participated in the transaction at issue. They did expressly say that Sync is liable, at least as a participant. I don't know offhand if how expressly they drew the line between Joplin and Olson speaking and the fact that that was on behalf of Sync. But the Commission's decision can be upheld for any reason that the evidence supports, even if the agency didn't expressly spell out that connection. And the evidence supports the conclusion that when Joplin and Olson were encouraging the investors to invest in Sync to help it grow, that they were speaking both as themselves but as Sync. They were acting as Sync, encouraging investment in Sync. And that's what happened. The money went to Sync, and some of the money was in fact used on to advance Sync's business. Now, Sync had no jury trial. I'm sorry, before I move on, one last point is that the Sync and the other respondents never raised a concern about this before. So the Commission's decision also shouldn't be overturned on a theory that the respondents didn't raise and give the Commission an opportunity to clear up. If they had filed exceptions to the proposed order saying this is not proper because you haven't proven an offer or sale by Sync, the Commission would have had an opportunity to remedy that with a more express finding.
You agree that no matter what we do at this point, we're not vacating as to Joplin and Olson?
I agree, Your Honor. Now, as to the Jarkissi questions and the jury trial question, Darendal versus Griffith answers the court's first question about jury trial rights. The Arizona Constitution preserves a jury trial right for a statutory claim only when its elements are substantially similar to a common law claim that had a jury trial right.
Could the ACC create its own version of the securities fraud statute? Say the legislature had never created the statute at issue here. Does the ACC have the authority to do that on its own under the Constitution?
I don't believe so, Your Honor, and the Commission's not asserting such a power right now. Okay.
I'm just hypothetically speaking.
I don't believe so, Your Honor. The Constitution empowers the Commission to investigate and require reports on the stock sales to the public. The Constitution didn't go so far as to enact securities regulation, although the first legislature did.
And couldn't the report require that they answer whether they fraudulently offered securities, and you have to check yes or no, and if they lie about that, the ACC could impose a fine or hold the company in contempt?
I suppose so, Your Honor, but if the company honestly answered that yes, they engaged in fraud, then the Commission would have no remedy based on the Constitution itself. It would have to be empowered by some other enacting statute to actually bring a claim, or else parties might bring a claim based on that admission.
You heard my question about what the overlap between an Arizona securities fraud claim and a federal securities fraud claim. What are your thoughts on that question?
The text is basically copied and pasted. I don't know that the elements are identical. There's federal case law that may interpret some of the elements in slightly different ways, but they're substantially similar, such that the Commission will routinely cite to and rely on federal interpretations of the federal securities fraud provision because there's parallels. One potential difference is I mentioned the SEC versus Aaron, where the U.S. Supreme Court finds that that the federal equivalent of 1991A1 has an intent requirement, or intent or recklessness requirement. And Arizona has not found that that's necessarily true. The Arizona Supreme Court says that requirement might exist, but no decision has been made. So there's a possibility that the elements don't completely align.
Counsel, in evaluating the elements and the Darendal requirements, looking at this court's subsequent case in State v. Lenoble, where we said, kind of the focus is whether the crimes are of the same character or grade, although whether they could be equated to the statutory offense, although the elements are not precise matches. So does that inform that perhaps we're not looking for, rote exact number or exact character of elements? It's more the overall look, which is a little bit what they were doing in Jarkissi. I mean, how do we apply that framework here?
So you're right that it says it's not a precise match, and when they say character or grade, that's Darendal citing Bowdoin from 1924. But Darendal says that the way you evaluate character or grade is by comparing elements. And Darendal says you don't evaluate character or grade by determining whether the clauses of action are related in some way other than their elements, which is the trap. Well, not the trap. Jarkissi doesn't do that. They have a different standard. They're comparing remedies. It's a remedial test. It's not a test of the elements. They barely compare the elements at all. And when they find one difference,
they do in some respect, right?
They
I mean, I know they focus on the civil penalty portion of it, but there is a portion of the opinion that does compare the elements of federal securities law claim to common law fraud, and says that is sort of, I guess, a kicker here as to why the Seventh Amendment applies.
So what they do is they note that statutory securities fraud doesn't have an injury requirement. But that's the only distinction they draw, when in fact there are many. 1991 A1 prohibits any employing any device, scheme, or artifice to defraud, and A3 prohibits any transaction, practice, or course of business that operates or would
So
operate
you're
as.
saying that portion of Jarkissi is wrong, or it's just, I guess, not adequately reasoned?
Well, it's not adequately reasoned because they're asking a different question. They're asking, do the elements relate to each other? And then, I guess, as you characterized it, at the end, they say, as an aside, there is this difference in the elements. The injury element is not the same, but that's fine because the causes of action are related to each other. They're talking about a historical relationship. But if the Supreme Court had been comparing the elements more rigorously, they would have found the differences. For example, 1991 A1 and A3. share none of the 9 elements of common law fraud. Neither one of those requires a representation to be made. And the first 8 elements of common law fraud are a representation and then 7 facts about the representation.
Do you agree with the state that the constitutional authority to impose fines makes this different than the SEC situation?
Yes, Your Honor. The commission, we don't think the court needs to rely on that because Darendal is sufficient to, the Darendal test is sufficient to show that there would be no jury trial right regardless.
But isn't it kind of down the analytical road?
Sorry, the what road?
Isn't Darendal, the Darendal issue kind of down the analytical road from an earlier question would be what the ACC's authority is under the Arizona Constitution. Wouldn't we want to resolve that before we get to Darendal? We make the Darendal analysis unnecessary.
That's fair, Your Honor. And yes, the commission agrees that based on the provisions of the Constitution, it should cause no concern that the commission held an administrative proceeding on a securities case that led to the imposition of an administrative penalty for a securities violation because the Constitution endorses administrative proceedings by the commission in front of the commission. It permits the imposition of fines for violations of orders and regulations. And if
that's our conclusion, then we don't have to reach whether there's a jury trial right when, for example, a private party brings a securities fraud claim against another private party in state court, or whether the ACC brings a securities fraud claim starting in Superior Court.
That's true, Your Honor. Although the commission, we're not taking the position that any decision here would necessarily impact private litigants. Our position is that JARCAC has no effect on enforcement proceedings by the commission. So I guess if you were to rely on the constitutional question, that would only answer the question of a jury trial right in commissioned administrative proceedings. The commission's position is that there's no jury trial right in a enforcement proceeding in Superior Court either, but that would require turning to Darendal, I suppose, which makes Darendal maybe the better resolution.
And that issue isn't strictly before us today.
Is that what you're saying?
So the issue that you just identified isn't necessarily before us today.
Because this case did not start in Superior Court.
Oh, that's true. That's true, Your Honor. That is correct. That wouldn't have to be decided today either way. But as to Darendal and the elements, as I mentioned, 1991, A1 and A3 don't share the 8 elements of common law fraud relating to a representation. We've already talked about the fact that there's no injury requirement for securities fraud, which is the 9th element of common law fraud. And 1991, A2 prohibits making an untrue statement of material fact or a omission of material fact that makes a statement misleading in connection with a securities offer or sale. And that also lacks at least 6 elements of common law fraud. There's no scienter requirement, whereas common law fraud requires knowledge of the representation's falsity and the intent that the representation be relied on. A2 has no requirement that the hearer be ignorant of the truth of the representation. A2 has no requirement of reliance or a right to rely on the speaker's representations. And A2 also has no proximate injury requirement. And some of the cases applying Darendal show that some of these differing elements are particularly important. In Darendal, there was a differing mental state element that was dispositive. So this is comparing a drag racing offense versus common law reckless driving. And the only difference that the court relied on to find those two to be distinct was an intent to race cars versus reckless disregard. And Mr. Escolar mentioned that securities fraud and common law fraud are equivalent because they are about the same core conduct. Darendal shows that that's not true because generally speaking, drag racing on a public street is the same core conduct as reckless driving. There's a significant amount of conceptual overlap there. But Darendal instead focuses on the elements. It finds there's this one difference, an intent requirement, a specific intent requirement of drag racing cars versus a general intent requirement of reckless disregard. That alone is enough to distinguish them. The common law offense is not an antecedent, so no jury trial right. And that shows that the State versus Noble language about the elements they don't need to be precisely the same, but Darendal shows that they need to be very, very close, because even two intent elements that are pointed in the same direction but don't overlap completely or nearly completely aren't enough. The injury distinction that the Supreme Court, U.S. Supreme Court, discarded is also dispositive, as discussed in Nyquist, where a statutory traffic offense of causing death or serious injury was not the same as dangerous operation of a motor vehicle. And again, the only difference relied on is the absence of an injury element in the common law offense. So in conclusion, the commission, sorry.
I think, can we add 5 minutes to each side, because I think the panel probably has some questions about the private offering issue?
Certainly.
Which we haven't addressed yet.
I would be happy to do that now. So the commission agrees with NASA's amicus brief explaining what the non-public offering exemption is. And the evidence here supported the commission's conclusion. There's a theoretical question about whether or not the investors needed the protection of the act, and whether or not that is what the Murphy test factors are about. You don't actually need to decide that if you don't want to, because the commission did address some of the Murphy factors, and its findings on Murphy would be enough to uphold the decision on that alone. The commission found that...
Counsel, although we may look to federal law,
Sure.
we're not required to, and as such, we're not required to be bound by the Ninth Circuit. So let's say that I found Murphy less persuasive and, what is it, Doran, the Fifth Circuit's articulation of the test, a little more persuasive, because Doran says that the sophistication factor is not so important. Sophistication seemed to be a really critical factor that the Corporation Commission relied on here. I'm not very persuaded by that factor. I think it's a very subjective test. So I'd like to, if you could focus on the relationship or access to information factor here. And I think Murphy and other cases really focus on the access to the information, not to particular documents, although it seemed like the commission's focus seemed to be more on whether or not particular documents existed or were available. So if you could talk to me about that space for this.
So the reason that the commission is focused on particular documents is that was a decisive factor for the court in Wales. The court in Wales noted that there was no balance sheet provided to the investors, and that there was, well, not provided to investors, it didn't exist as far as anyone had proved, and that there was no opinion of counsel about the legality of the offering. And in the Wales case...
But do you disagree that the information that would have been present in that type of, in a balance sheet or other relevant documents of that nature was available here, which we can tell because the commission was able to get at that information during the litigation?
Well, the fact that the commission was able to get at that information during the litigation doesn't prove that it was made available to the...
Not made available, but was potentially available to, right?
So the test is, do the investors have a relationship with Sync that provided them access to accurate information about Sync?
Right.
And the answer is no. One of the first representations that Ms. Joplin made after proposing this is she claimed she was a CPA. That was false. One of the first things they said was false.
Well, that's a disputed fact. So let's, I guess what I would like to get at more is not, so the information that we're talking about is the financial information, right, of Sync. And we're talking about the kind of relationship they had. There's a lot of information in the commission's presentation before the commission and before us about subsequent to the breakdown of the relationship. But before that, the information, the testimony is somewhat uniform that the parties were actually very close, that they had a lot of communications back and forth, that there were a lot of questions, there was a lot of access, just general access. I don't mean access to specific information. So if you could talk about that time frame and something that tells me, had the Williams requested this type of financial information, it was not available, it didn't exist or was not available.
So it's not just, is it available, it's if they had asked for it, would they have gotten what they asked for? And looking at what they got when they eventually asked for, which is nothing, a hostile refusal, informs what they would have gotten if they had asked up front.
Well, there were some things that happened in between there that perhaps led to the hostility, like demanding your money back, which maybe they were perfectly within their right to do, but there was a very different factual scenario happening at that point.
Yes, Your Honor, but the reason the investors were frustrated was that they weren't being told what was going on. There was some holdup with the license. The company wasn't open on time. They asked why, and Mr. Olson just stalled them for a month, didn't answer their questions, said, I'll get back to you, or just ignored them. You mentioned that the evidence was undisputed, that they had a close relationship. I don't think that that's undisputed, Your Honor. There was an agreement that they had a social relationship, not that there was a relationship that provided them access to information. The individual respondents certainly argued that. The commission was not required to credit any of that, and the commission chose not to. The commission looked at the competing evidence, and it decided to weigh the evidence that the investors were not told the truth. Another example being that shortly after the investment, Mr. Olson represented to them that we just filed an application for a license. I can't remember which one. I think it was a title license. I don't remember which one. That was false. They never filed that application. So when the information came, it was often false. And when the information was eventually asked for in more detail, it was rejected. And I see that I'm out of time. Happy to answer the question further if I haven't done so to your satisfaction.
Thank you.
Thank you.
Good.
Thank you.
Thank you, Your Honor, for the extra time here, which I presume should be focused on 1844. And that, of course, was a point of great frustration throughout the proceedings, how we believe Olson and Joplin really did establish well, as inferred in the prior questioning here, that they not only had a very close social relationship, and I think the evidence showed that the until there was a breakdown in the communications, the flow of information was free, and the flow of information was as accurate as it could have been at that time, at least prior to the investment and at the time of investment. Things start going pretty poorly after that, admittedly, and eventually completely breaking down. But to the time of investment and prior to that, they have free flow of information, and I think in our briefs we listed many, many examples on how there was no delay with respect to sharing the information, and how they had essentially a rather envious relationship in terms of proximity.
But what do we do with your colleague's point here that we also have this evidence at some point when more specific questions get asked, the responses are either false or don't answer the questions, don't provide the information?
Right. I feel like those occur post-investment.
But doesn't that still inform something about the relationship?
It still does with respect to the relationship. I think it informs us that the relationship is going sour, but the prior to it going sour, and I think the error with the Department of Financial Institutions was one of the really, really big problems that they had, as well as some regulatory delays in general. And I'm not so sure that the record shows what Mr. Kitchen was referring to regarding the non-filing of a license application. I think it was filed. It just was substantially delayed because they did not file additional documents in support of it, and therefore the license didn't kick off for a while, or the regular process. I think that's what the record actually shows. But with respect to 1844 and their relationship, going back to that, we feel like the commission made a really serious error by almost adding an additional factor that, injecting whether or not these people just need to be protected by the act. That's like a fifth factor for Arizona, in addition to the Murphy test. We think that was improper, that the Murphy test answers whether or not they need the protection of the act. But to your earlier question, Judge Perkins.
But doesn't Ralston Perina have that language?
Yes, it
Without needing
does.
the protection of the act?
Absolutely, yeah.
I guess what you're saying is that the four Murphy factors or the factors in Doran are the tests for determining whether
That's
they
correct.
need the protection.
And I think even you could view Doran as almost a further refinement of it when, let's take a look at the relationship of these offerees. If they just have access to the information, I think the language in the case is pretty emphatic. The analysis can almost end there if they've got the relationship to have access to it, rather than focusing on, which the commission did extensively, whether or not certain documents were produced. That was constantly a theme at the Superior Court level as well as at the commission. All the different documents that did not exist, therefore, they didn't have access to the information. We don't believe that's the test. Not whether the information exists, whether they had access to inquire about that information that might lead one to create, say, one of those documents, if it even exists. In a startup, obviously, there's a large class of documents that won't exist that might be required in a lot of securities registrations. So the fact that these documents didn't exist, we don't think that's dispositive or frankly even informative. Did they have the appropriate relationship? We believe they did. And that said, with respect to sophistication, we believe at least to the extent it should be applied in Arizona, the Murphy test, they showed more than enough sophistication. So I have 30 seconds. If there's any final question, I'd be happy to answer it with respect to 1844.
What is the test for sophistication?
Do
They have to be sophisticated?
Smarter rich, I believe, is what the court used. That's not my word. And I think that's a fair test. Now, of course, how smart, how rich, of course, I think is up to this court. Thank you, Your Honor.
All right. Thank you, counsel, for your argument this morning. We will take the matter under advisement and get you a decision in due course. Thank you. Thank you.